Hello viewers, you are watching the Doordarshan Kendra Kohima. Welcome to another episode of Talk and Know, where we discuss topics that matters the most. In this episode, we will discuss on the new criminal laws with regard to the Bharatiya Nyaya Sanhita, the BNS, the Bharatiya Nagrik Suraksha Sanhita, the BNSS, and the Bharatiya Sakshya Adhiniyam, the BSA. These three new laws that have come to force on July 1st this year across the country. Now, to understand what changes have been made and to dive deeper into this discussion, I am joined by Mr. Vikram Kalate, IPS. He is the IGP CID of Kohima. Thank you very much, Mr. Kalate, for joining me.
Thank you, Midhu.
So, we had some discussions on the new criminal laws in the past episodes.
Okay.
Now, in this episode with you, we will dive into crucial topics, particularly with regard to the provisions that concerns women and children, organized crimes, mob lynching, and I would love to take your opinions on that. I'd like to start this conversation firstly with asking you, if you could give an introduction on what laws have been made, what changes have been made, particularly with regard to women and children in the three new criminal laws.
Madam, this is a very good question. Thank you very much. And I would like to say hello to all the viewers. This is a very, very crucial topic which as a Indian citizen one must understand. The very essence of bringing these laws, why it has been brought. So, if we go into the parliamentary discussions and go into the procedures which are adopted prior to making these laws functional, there is a lot of effort and lot of labor has been in placed. So, therein the major thing, the IPC, the previous law, Indian Penal Code 1860, Indian Evidence Act 1872, we all know these are very old laws and made in keeping in mind by the Britishers their own interest in India and to perpetuate the same interest. But since India is an independent country since last 75 years after 1947, and with the procedures and all that, we found that there are certain things which need to be looked into, and all those aspects were kept in mind, and all that sagacity or a clarity which we would have been got in last 75 years of our independence. So therein they just went with a more and more clarity, and now this has to be brought in way into the law. Like Supreme Court multiple times gave a different decisions which also need to be redressed somewhere. So all this ended up into we getting three new criminal laws.
Right.
As you said clearly, that is number one is your BNS, that is Bharatiya Sakshya Adhiniyam, which replaces your IPC. Then BNSS, Bharatiya Nagrik Suraksha Sanhita, which replaces your CRPC. That is a procedural law. Number one is a substantive law. And third is BSA, which is a Evidence Act, which is Bharatiya Sakshya Adhiniyam. So the major changes which are brought pertains to the documentation of evidence, that how to bring this electronic thing, because there is a lot of changes with the electronic evidence around. How to bring it in make it a part of a mainstream evidence deposition in the courts. Then to redress the delay in trials, to make it more functional, the whole machinery to make it more and more functional by eradicating all the previous issues with the system.
Okay.
So as you put a very nice question initially, I said thank you for that. It's a crime against women and children.
Right.
So this is a area which was very, very important, wherein if you see there is a exploitation of women happens on a pretext of false promise of a marriage.
Okay.
So there was no such a provision to protect that particular aspect. Someone will just promise some lady that we will marry, and they will indulge into some more further steps. They may sometime go into the living together and again going further.
A form of deceit in this case.
Exactly. So this particular thing marriage, false promise of marriage has been covered, which was a new thing. Secondly, they tried to go here gender neutral, because for this minor girl, exploitation of minor girl was there in the previous laws. Now they made a child.
Okay.
Whoever is below 18 years, it's child.
Irrespective
It's
of
a
the
boy,
gender.
irrespective of boy or girl. So both have been brought into the ambit of law.
Okay.
Because exploitation might happen with the boys also. So that way they try to make it a gender neutral. Then the punishments, if you see, they have enhanced the punishments. They have made a categorization like a women exploited, like a sexual intercourse below 12 year, 15 year, 18 year. So 3 categories have been introduced.
Okay.
Even there is a change with a consent, like marital consent particularly. If a marriage happens and what exactly will be termed as a marital rape or not. So that also they brought a new changes. And the punishments are made more stringent, but I can make it out. And it is in tune with the provisions of a POSCO Act, which is already there in place.
Okay.
And that way there are a lot of good provisions have been brought, which will definitely take care and protect the rights of women and children.
So you mentioned the POXO Act. It's already there. It's a separate law. Now, do you think there could be an overlapping of the Act with the new laws?
I don't think there is overlapping because there are multiple provisions have been brought into, like the next topic also, like next topic I was about to come to that, which relates to the terrorism thing. There is a law, namely UAPA, to take care of terrorism thing, but still those provisions which are required are introduced now into the substantive law, that is into BNS. And those provisions are not going to in any way, rather it is going to be complement each other.
Okay. And in terms of the protection and delivering justice for women and children, how does this new laws compare to the previous ones that were in existence?
Protection and giving justice, definitely, particularly now we need to look into the aspect of the judicial this thing. So therein a lot of changes have been introduced, like for any serious offense, they have introduced the separate institution, that is a Directorate of Prosecution. For that they have to seek a opinion wherein there is a punishment of more than 10 years. In BNSS, they have very categorically mentioned about a provision of new things for the purpose of giving a speedy and expeditious justice to all the victims. Apart from, I can't make it only for child and women, but for all the categories of the victims, there are a lot of victim-centric provisions have been brought into.
Okay.
So if you see, they are highly oriented towards the welfare and the betterment of the victim, in a way that, number one, there is a lot of accountability has been introduced for police officers. Number one, starting from the arrest, informing to the family members of an arrested person, a separate register to be maintained in the police station, and then going with the absolute clarity from the first step after arrest, like still handcuffing. Lot of clarity have been given, and all the procedures have been codified and mentioned in the laws.
Okay.
Because previously we were just going by the precedents, that what courts have different says in a different decisions, so all those things now brought into. So when again going to that giving speedy justice to all the victims, and why I am saying these laws are highly victim centric, because number one, what I feel, there is a clear cut bar have been given for the courts to decide a trial. Like in a certain time they have to frame the charges. Charge framing, like after this committal of the case, a time has been allotted for a framing of charges. Then discharge application to be decided in a certain time. You just can't keep discharge applications loitering, because previously there was a practice that one accused after another will keep on filing the discharge applications, which will delay the procedure, delay the time of a court. It will kill the time of a court, and the justice gets delayed. So that is also clear. Now a lawyer cannot take adjournments again and again. Previously, like a defense lawyer on some pretext or other, they will keep on taking adjournments. So that is also stopped, not more than 2 adjournments.
Okay.
Then again, if you see, in all the serious offences, opinion of a legal officer, a police officer can seek, so that the legal officer giving opinion on a charge sheet, like prior to filing the charge sheet into the court, that will definitely strengthen the evidence part.
Okay.
So that way also it is made victim friendly. Then providing a copy of a victim, a copy of a charge sheet to the victim along with the accused to his lawyer, and most importantly telling the progress of the victim. At every stage of investigation, victim can be briefed about the progress of the investigation, and this what I feel is a massive or a major like a step, because it was nowhere covered previously. Now victim will be briefed by the police officer. So more accountability they wanted to introduce, and even recording of a statement, then protection of witnesses. All those are fantastic steps.
Okay.
Because why I feel, because if a victim is there and if a case is a serious nature, and sometimes what happens, a witness is there. So when witness deposes something before the police officer, so there to keep it more intact and that evidence make it more appropriate and proper. Now audio video recording of that particular witness.
Now these are all part of the investigation process.
And here, you know, like the interesting part is that like witness telling something in a 161 statement, previously it was called, to the police officer. Now it can be recorded. A procedure can be adopted to protect that electronic record properly, and that can be given as a evidence in the court.
Okay.
So the electronic evidence is now made as a primary evidence. Previously it was not. So this is a new introduction. So that way it covers that aspect also. So it's highly giving a speedy justice to all the victims.
Okay.
What I mean to say. Yeah.
That is inclusive of women and
Everything,
children.
yeah.
Also, can you tell us more about the investigation process, particularly when it comes to women and children? Are there any kind of specific provisions, measures in the new laws that protects them primarily?
Yeah, there are multiple provisions in all the 3 acts, and they have introduced a separate chapter rather
Okay.
on these women and children. And all these procedures and these provisions given, the categorization and all that, which is like that way we have already I think discussed in the previous one, but still like in every respect it is favoring them. That way I would like to say.
Okay.
Yeah.
Okay. And now I'd like to move to another topic,
Yeah.
which is on mob lynching
Yeah.
and organized crimes. Now,
Yes.
if you could take us through what are changes in the new laws concerning this, because I think the nature of crimes has evolved in comparison to the laws that were in existence to regulate
Yeah.
these crimes
Yeah.
when the old laws were in fact enacted.
Yeah.
So can you draw some comparisons? Also give us help our viewers understand what mob lynching is and what can be termed as organized crimes.
Yeah. Specifically regarding mob lynching, the provisions have been made without mentioning the word mob lynching directly, but they made a very clear provisions regarding more than 5 people coming together and doing that kind of offense, that is killing or hitting someone or doing offense against him or her on the basis of his caste, creed, culture, religion, or multiple different aspects. So on that basis, if it is specifically a group of persons targeting someone, so that particular aspect has been covered nicely into these new laws.
Okay.
And which is in tune with the previous guidelines given from the apex judiciary and whatever like the different evolving nature of a crime. So that way it is for mob lynching. Secondly, for organized crime and even terrorism, that section 111 to 113 of this new BNS. So this BNS mention about it. Organized crime is people coming together and committing a crime, and then like it's a serious nature crime, and then even a act, that is a terrorist act, which is also categorically defined. What is a terrorist act? So act which will damage the public private property, and then like will damage to great extent the even the social fabric of the public and all that, public tranquility and all that. So this terrorist act and mob lynching and even organized crime, these are the new features which are defined, they are codified, separate sections have been given, and that is the thing, it is like widening the jurisdiction of the existing laws also. There was a law specifically dealing with the terrorist act, that is a UAPA, Unlawful Activities Prevention Act.
Right.
But now along with that, this has been introduced into the BNS. So that way it is giving more clarity and power and understanding to the all the system throughout the country, wherein this can be like used in a manner so as to meted to justice to the victims speedily. So this is also there.
Is there any chance of the police abusing their power, because there's provisions under the new law with regard to terrorism and also the UAPA Act? No.
I don't think so, because police is made highly accountable to great extent at every respect. Even I tell you, like why we say the police abusing power, because there is something, if you see the custody particularly, I would like to elaborate it with the help of a custody thing. Like previously there was a 15 days of police custody after the arrest. Like one was supposed to get, like the prosecution gets or a police gets. So that 15 days police remand was in the first 15 days after the arrest. That was there. Now what has happened? They have made a 40-60. So what is 40-60? That is, you can spread these 15 days in the first 40 days.
Okay.
Like you can take 5 days. Again, if someone new person gets arrested and you want to confront the person in jail with the newly arrested person, then you can again seek the custody. Again, third occasion also you can take a custody, but you have to finish your custody period up to 40 days.
40 days.
So that way, if you see where the charge sheet to be filed within 60 days, there you can spread your custody period of 15 days for total 40 days. And the another provision is 60-90. So where you have to file a charge sheet in 90 days, you can spread the custody period for first 60 days. The custody period remains the same. It is not changing.
Okay.
So that way, if you see, this is rather better in a manner, because many time like a person is in judicial custody and a new arrest happens. So their police officers get stuck. Like they want to confront the previous, because the person who is in judicial custody, he will take a plea ki, I don't know anything, everything has been done by the another person who is now absconding.
Okay.
Now there is one can't take that plea. Now he can be easily brought again, custody
Okay.
can be sought, and they can be made to confront each other, and the claims can be checked. So this will help the investigation officers to great extent.
So,
that way,
my general understanding is that in that case, there will be 15 days. The person within this short period can be interrogated for 5 days, can be released and be brought back.
Exactly.
Is that what you mean? Or?
Yeah, he can be kept in the judicial custody. We can't release him.
Okay,
He can be in the judicial custody during that time. So he will be in the jail, and again he can be brought back into the police custody.
Okay, okay.
Police custody remand.
Okay, okay. Now, if you can tell our viewers, what could be the difference between a judicial custody and the police custody?
Police custody is a simple thing. Like once a person is arrested, the police officers take him in front of a judge, and they request the magistrate to give the remand. That is a police custody remand. We call it as a PCR. So police custody remand is the remand period in which or wherein police officers ask him or try to get the clarity in the investigation and try to take his statement in detail, so that evidences can be collected accordingly as per the nature of a crime. So that is a police custody remand, where the accused police have been given access of the accused directly, and the accused remains in the police custody. That is generally in the police station.
Okay.
The police station, there are lockups, you might have seen. So they are into the police custody remand. The judicial custody is that once this police custody remand period is over, the accused taken to the again in front of a magistrate, and then they are giving this thing, okay, now we are sending him into the judicial custody remand. So JCR is like he is sent to as a under trial to the jail. Yet the trial has not taken place, so he is termed as under trial prisoner, who is there in the jail.
Right.
And there people are like accused are kept there. So now from that judicial custody, if you have to take police custody again, which was very difficult in previous case, because you can have police custody remand only in first 15 days. Now they have made a change ki, okay, even though he is in judicial custody, and if the police feels like his presence is required, and if they have not exhausted those 15 days, so he can be again brought back from the jail to the police station at their custody.
Okay, but that should be within 40 and 60 days.
Yeah.
Okay.
Within first 40 days for offences to be charge sheeted in 60 days, and for in first 60 days when offence to be charge sheeted in first 90 days.
Okay. I think this conversation is actually very interesting, but we would continue with the arrest, remand and bail later on. Now coming back to our discussion on organized crimes, if you could tell us measures in the new laws that suggests how to handle or prevent organized crimes.
The first thing, organized crime has found a clear mention. So measures to combat organized crime remains same what police was doing previously also.
Okay.
But out here, since organized crime where people, more than 5 people coming together, and they are committing some offense, which is a bodily offense or which is damaging the public property or even a private property. So those kind of things can be tackled out here because it is made a very serious offense. And the punishments also varies from, you know, like imprisonment from 10 years then up to life. Even if it results into death, then it go up to death penalties. So they have made a stringent provisions.
Okay.
And secondly, because organized crime, again they have mentioned a terrorist act also, just in continuation, because the sections also in continuity they come. So terrorist act also, like whoever like willfully indulge into like committing act which is against the public order or against the you know, the overall unity integrity of a nation, then which is having potential, or it is done with the usage of a WMDs or a biological weapon, or with the help of a like bombs or with some explosives or with the help of some pistol or some firearms. So that, and it is generally to create a kind of a fear or a kind of a this thing into the general public's mind. You know, it is an act which creates a kind of a insecurity into the minds of a general public. So that is a terrorist act. So previously, like there was a special law and it was dealt with the UAPA under UAP. But now because it has been already codified under this BNS, so that way it is to great extent will give a clarity to all, like to deal with it throughout the country, because previously to great extent the UAP related offences, you know, like the specialized agencies will do, or even in state setup. So that way they have widened the ambit of dealing with it with the help of putting it into these new laws. Yeah, I think.
Will any situation arise where the UAPA could take over the one of the new laws?
I think special law to take precedence as per the this thing.
Okay, special law to take precedence.
Yeah,
that's a very interesting point again. Now, I also want to understand the new criminal laws in terms of witness protection. You've mentioned earlier, in fact, something that interests you as well. If you could tell our viewers, how do you see these changes, if there has been changes, if you could highlight some of this?
Protection of witness previously also was there. In the previous CRPC, a mention is there.
Okay.
In majority of the special laws, particularly like UAP and all those also, they mention about a protection of witness. Now the government has asked with this clear-cut witness protection scheme to be made.
Okay.
So all the states have been made responsible to codify, to find it out a way by which they think like which way the witness to be protected. Now why this has introduced and what is the requirement?
Right.
Because we see in many important cases, like previously there was a provision of making a protected witness. What is protected witness? Protected witness is that you are not mentioning anywhere his name, even like whenever you give his statement, a copy of his statement. So that time there is a provision in previous laws also and these laws also.
Okay.
Like you have to give the copies of a statement of witnesses to the accused and his lawyer. They are entitled for that.
Okay.
So the protected witness statement, when you are supposed to share with them, you will take out the important portions which will reveal his identity from the statement.
Okay.
His name, his address, his school, the different places which are like you know, surface his identity are to be blurred or are to be deleted from the statement. So this was there. Again, what is there to protect the identity of witness is that, like when he has to depose in the court, the trial will be in camera trial. What is in camera trial? Therein, like no one will be present apart from the witness, judge and the lawyers.
Okay.
So like whatever he is deposing, only like the learned judge is making points out of it, and no one is like, you know, like asked to or allowed to like make his identity public, because there is a threat to his life. Even the families of a victim, families of a witness can also be protected.
Okay.
So protection, they can demand a protection. Protection can be given from the end of a state.
Oh, what
So
kind
we are
of protection, if I
still
may
in
ask?
the protection is like sometime, you know, like in some serious offences, sensitive offences, uh, victim is already he's a victim, but the family of victim is again provided with a special police for guards, like
Okay.
police guards have been
Okay.
given to them for their movement and all that.
Mm-hmm.
Even in some of the cases, because there is a threat to life of a
Right,
witness,
right.
particularly say for example a heinous crime like a rape, victim is again a witness. She is not only a victim, she is a witness also.
Right, right.
So her life is very crucial, and protection of her life, her safety, security, even her family members are under threat sometime. So there are provisions have been made, and states have been asked to discuss and find out the modalities regarding for the protection of witnesses. Similarly, like collection of, you know, the evidence, if you see, because in some of the cases even the evidence can be collected from the accused also, because accused is not only like accused, like he can, like his even medical checkup can give you some evidence.
Right.
Say for example, if he is indulged into harming someone, and in the course of that he also gets some bashing or some harm, or in offences like, you know, crime against women, many times its medical examination is very much required.
Right.
So that evidence also can be taken. Now here the introduction of forensic science related tools and the experts for the purpose of using them wherever there is a punishment of more than 7 years is mentioned in the new criminal law.
Okay.
So wherever there is an offence committed having punishment more than 7 years, you have to take the help of a forensic experts. You have to videograph the entire crime scene.
The investigation process.
Exactly, it's an investigation process.
Okay.
I am saying, because it's all related. Why I'm like we are going from one to another, because it's like in a smooth way, because it's all interrelated things. It is again comes as a strengthening of evidence. It is again favoring the victim of the offense, because if a new technology has been introduced in the form of search and seizure proceedings, so there, you know, like the right of the accused also is protected, because in a way, like whenever a team of officers or a team of a police goes for searching a particular premises, they have to videograph the whole procedure. They have to finish the memorandum then and there. You have to obtain the signatures of the witnesses then and there. Then after the completion of that document, you are giving a copy of document to the house owner, or in whose house the search have been carried out, or a place, whoever is the owner of that particular place, you have to give a copy of that.
Okay.
So once it all has been done, you are videographing it. So that whole videography, you are like you have to maintain the hash value of that particular video, starting and ending, and you have to take out that particular video into a CD or a pen drive, and that becomes a part of a document.
Okay.
This is an electronic record, but it is again considered as a document, like a primary evidence.
Right, right.
So as previously it was only search memo, which we are giving as a primary evidence. Now we are giving that videography also. Now apart from this, you are also involving the FSLs.
FSL.
Because
so
why FSL? Because say for example, if you have to take some electronic evidence, say there is a hard drive inside a it is inside a say for example CPU.
Okay.
So even to how to remove hard drive is an expert's task.
Right.
If you just like go and take the whole CPU, that is you know, like that is not a way by which you just
Could
have to
damage
take
the
that.
evidences
Yeah,
also,
you have to
right?
take an exactly. You should not tamper with the evidence. The tampering of evidence to be avoided. So what FSL people will facilitate, they will help us to get a hard drive properly. Say for example, if there are some fingerprints to be lifted, now policemen will also will try, but FSL expert being there, again we will be in better poised to get the better evidences. So that way. So this is the thing where FSL's role comes in picture.
Okay.
And all these documented thing, which is again videographed,
Okay.
is part of evidence.
And these are all very interesting procedures. Very briefly, you know, if you could tell us what could be the challenges of implementing the new laws?
The challenges is like where to store this data, then whether it is possible in a cloud, or again you have to get a separate kind of a like we call it as a big servers to store the data. So that might be one of the challenges
Okay.
which state have to work out and find the modalities like how to tackle this particular thing. Then secondly, if you see like FSL needs to be strengthened. Then whether the existing infrastructure available with FSL is suffice to take care of the crimes in the entire state. So that is what I feel is another challenge.
Okay.
Thirdly, how you will give those devices for the recording purposes. A lot of expenditure is involved, whether it will be recorded from the police officer's mobile phone or a separate memory card along with a camera to be used.
Right.
So all these things, because that again you have to maintain a chain of custody. You have to maintain the sanctity of evidence.
Okay.
You just can't go like just going and doing some recording and coming back and again issue that, how to take out that clip. So those kind of things are there. How to submit it in the court without
many real life challenges
yeah,
here.
so there are many real life challenges,
Okay.
and this is definitely it will take some time for everyone to training part is very crucial and important, because now say for example everyone which is having an absolute understanding about these laws and procedure won't be available on the ground. So on ground personnel who are actually going to deal with this kind of handling of a scene of crime, then handling of the evidence need to be trained. And that therein states need to find out modalities to bring more clarity and to strengthen their basic infrastructure for getting a full-fledged rolling up of these laws. What I feel.
And while we have this 3 new laws coming into force across the country starting the 1st of July, we've heard from our expert about some of the laws in details. We've also heard the challenges that could be in implementing these new laws. I wish you, Mr. Kalite, and the police force the very best in implementing the new laws. So viewers, this was a discussion on the new criminal laws. I hope this session was as informative for you as it was for me. And thank you for watching us. This is Mr. Vikram Kalate, IPS, the IGP of the CID, who has shared his insights. Thank you very much. And I'm Madeline Imbrisia signing off from Doordarshan Kendra Kohima. We'll see you in the next one.